Yes, Harrington here. Here we go, guys. All right, back from a 1-week hiatus. But we were diligent in the meanwhile. My Bangladeshi Shimul, shout out, took advantage of that 1-week break to take this podcast, Our Practice Makes Perfect, and put it up on Spotify. So if you like to do your podcasts and get them from Spotify as opposed to YouTube, please come check us out. But let's pick right back up where we left off 2 weeks ago. We were talking about asset protection trust. Topic that I very much enjoy talking about, and a topic that I've been getting lots of questions about in recent time. In that episode 38, we touched on the main key components of an asset protection trust, which are irrevocability and having somebody else named as your trustee. Now today we're going to talk about what is called a self-settled asset protection trust. Spoiler alert, I'm not a huge fan, but it does have some palpable advantages, so let's talk about it. Here we go. Our Practice Makes Perfect is the podcast for business owners and real estate investors, siempre con un cariño especial para los clientes extranjeros. All right, so first of all, what is it? What makes a trust self-settled? I mean, it's a bit of a misnomer to begin with, don't you think? They're all self-settled trusts in the sense that you're the one setting up the trust. But what we mean to say by self-settled is that you, the person setting up the trust, are also the person named as the beneficiary. Let that sink in. Why would that be a desirable feature? Well, you don't have to bother anybody else. You don't have to trust anybody else. You know, you're the one who creates a trust. It's created for your own benefit. It's strictly to protect your assets. So that's very convenient. Now, not all jurisdictions will recognize a self-settled trust. Some jurisdictions will consider, like Florida, for example, or California, they'll say that, look, if you set up the trust and you're also your own beneficiary, well, that's not really a trust. You know, it kind of defeats the whole purpose. But there are a few special jurisdictions that do recognize self-settled trusts, in particular for asset protection purposes. Basically, they say, that's okay, we're good with that. Like Delaware, for example, Wyoming, which is probably your best bet if you want to do that. Alaska is another one. There are a few jurisdictions, you know, some of Nevada, the usual suspect. But I did confess off the top that I'm not a big fan of the self-settled trust, and I'm going to tell you now the reasons for that. All right, let's call this part one. So, you know, I understand that the asset protection trust is not for estate planning purposes. I get it. However, what if you do die? You know, you've set up this trust, you've named yourself as a beneficiary as opposed to an heir of yours. And if you do die, then I guess it's just useless, right? So for starters, unless you just don't have anybody in your life that you want to name as your beneficiary, you know, a child or a spouse or a charity, you know, if you just don't have anybody, then okay, maybe self-settled trust would make some sense to you. But otherwise, why not take advantage of that estate planning component and make a trust that will actually be worth something in the unfortunate and unlikely event of your death. But that's just for starters. I guess what I'm saying is it's kind of counterintuitive. Maybe here's a more important point. I told you that not all jurisdictions, in fact, the majority of jurisdictions do not recognize a self-settled asset protection trust. So let's say that you create this trust in Delaware, as an example, which does allow this, but your Delaware self-settled asset protection trust gets sued in Florida. All right. Now what happens? Is the Florida court going to simply strike down your trust and allow the whoever's suing you to pierce right through it and get to your personal assets? There's a distinct possibility of that happening, yeah. Now you might say, well, Jeff, if it's a Delaware trust, then in most cases, probably it has to be sued in Delaware, right? Yeah, that's not wrong. However, there's a chance that you could be hauled into court in some other state, and do you really want to risk that? Okay, let's call this part two. So, episode 38, we talked about irrevocability, right? That it's very important. The whole concept of control is key in most of the states throughout the U.S. When it comes to an asset protection trust holding up. So if the court thinks that you are the one in control of the assets, then the court will say, well, those are your assets, and we're going to pierce right through this trust. Okay, but, you know, I guess this is on the positive side. These special jurisdictions, like the ones we just talked about, Delaware, Wyoming, Alaska, Nevada, they will allow you to have some limited control over your trustee. Now that's a beautiful thing, right? Now you really do have your cake and you can eat it too. In other words, you can get your asset protection without giving up the control to some other individual, some other trustee. That's beautiful. Now, what do these control mechanisms look like? Well, let me give you some examples. For one thing, you would, in many of these jurisdictions that allow self-settled asset protection trusts, they will allow you to replace the trustee. Like you yourself can't be the trustee. However, if you have the ability to replace the trustee at any time, well, that's a nice protection for you, right? Here's another one. You might have veto power. So if your trustee goes rogue, does something that you disapprove of, you can veto that. That's also a mechanism that many of these jurisdictions do allow. So beautiful, right? Yes, as long as you remain in one of these states that allow those kinds of mechanisms. Now let's parse this down a little bit and let's get back to our previous example of a Delaware asset protection, self-settled asset protection trust that gets hauled into court in Florida. All right. Now, as you guys know from the many videos and articles I put out on this topic, I love the flexibility and the confidentiality of trusts. Just for moments like that. What do I mean? Okay, well, let's get real here for a second. Your trust exists as a document that's not recorded anywhere. You don't have to, in many cases, you do not have to register it with any State Department. It's just a piece of paper that's in your safe at home or in my archives. That's it. So in that scenario where your trust, which would be recognized and honored in Delaware, gets hauled into court in Florida, what's to prevent you from just hastily swapping yourself out as the beneficiary? Put somebody else in place at that time. That's not bad. I mean, who's going to know? So I guess that would be one of your solutions, right? That would be a comeback to my criticism of, the self-settled trust is vulnerable in other jurisdictions. Well, you could just simply use it unless and until that scenario arises and then make the change and you're probably good. Okay, fine. However, let's get back to those mechanisms now. These control mechanisms, that creates an additional vulnerability to your trust. So you can quickly and easily swap yourself out as a beneficiary and put somebody else in your place and it's no longer self-settled. However, if the trust agreement also has built in these different control mechanisms that are permitted in the specific jurisdictions but not in the state of Florida, now you're looking at rewriting the entire trust agreement. Now, maybe you would say that's not the end of the world if you have to rewrite the entire trust agreement. Under your circumstances, maybe that's the poison you prefer to take. And that's true. It's not the end of the world. It's not that big of a deal. But, really, aren't we reaching the point where you're kind of defeating the purpose? Why not just set up the trust in a different, maybe what I would call better way to begin with? Now, let me just digress here just a little bit, but it's certainly relevant. Look, what are some of the things that we're aiming for? Some of the things I aim for anyway when I do these kinds of trusts is I'm trying to do it as streamlined as possible. We're going to get into that in part 3, but another thing is this, is maintenance free as possible, as cost efficiently as possible. And if you're having to redo your trust whenever circumstances arise, that kind of doesn't meet those goals. In fact, what I'm really aiming for is this. I want to put together an asset protection plan that you're not going to have to, it's going to be as convenient as possible, remembering, like I said in episode 38, that there is a trade-off between convenience and the level of protection. But, we'll find the perfect balance, ideally the best possible balance, and we'll run with that. And then the other thing is this. So we get the confidentiality. That's a very important component of any asset protection plan. And then I always have in the back of my mind this, because how is it that somebody can pierce through that confidentiality and find out what's really going on? Well, they can put you under oath in a deposition. And if they're skillful, they'll ask you the right questions, and they're going to find out about your trust, and they're going to find out even about the way it's set up, because you're not going to lie under oath. So at the end of the day, what we're really aiming for is an asset protection plan that just doesn't make it easy for these guys. Let's just not be obvious, right? And then even in that scenario where you go all the way to a deposition, you're under oath, and you've got somebody skillful enough to know the right questions to ask you, that you can answer those questions honestly, and there's nothing they can do about it. That's ultimately what we're really looking for. And that kind of gets me to part 3. let's talk just briefly about a two-layered approach. What do I mean by that? I mean the combination of, let's say, an LLC and a trust. Really, it's just a combination of any two entities, but that's the two-layered. Now let's just take a half step back, because I did just say that we should keep these things as streamlined as possible. And now if we're having entities that own other entities, well, you can really spin off into a shell game, right? You got your British Virgin Islands LLC that's owned by your Cyprus Trust, that in turn is managed by your Panamanian Foundation that has its directors, which are, you see what I mean? You can add as many layers into this thing as you want. Why not do that? Well, one, is terribly inefficient. Two, the cost of setting it all up and maintaining all that is going to become inefficient. And the accounting is going to be a huge headache. I mean, it's just, let's try to keep things as least complicated as possible, but providing the protection that we're going to need. So with that caveat in mind, it may in many cases be worthwhile to have at least two layers. Let's say an LLC that's owned by a trust. Why would that be? What are the advantages to that? All right, let's harken back to a previous conversation about where the threats come from. Most of the time when we're talking about asset protection, people are thinking, I want to protect my personal assets. So, if something happens to one of my companies or one of my ventures, and that gives rise to litigation or whatever, problems with governmental authority or something like that, I want it to end with the entity. I want those to be the only assets that are exposed, and that this threat can't reach me personally. Okay, usually that's what we're thinking about, and that's certainly something good to think about. But the converse is also true, or can be true, right? That maybe the threat is against you personally. There are many things that you can't avoid. I always think of like a car accident. Maybe you get in an accident and it was your fault, and there's not enough insurance to cover the injuries of the other party. So that lawsuit's not going to be against your company. It's going to be against you personally. And in that scenario, you may want to, you realize that your personal assets are going to be exposed. There's no way to avoid that. But why not protect your company's assets? So you see what I mean? The threats can come from either direction. They could come against your entity and you want to be shielded, or it could come against you and maybe you want to shield your entity. Okay, so let's take these one by one. All right, so start with a threat that comes against your entity. It's like it's a business-related, attacker. Well, just the very fact that you have some entity set up, assuming it's a corporation or an LLC or something that provides a corporate shield, then, that's good. That's good protection, right? Now, that's the way it's supposed to be. All states recognize the corporate shield, and for the most part, it's quite good. So that's good, but there could be circumstances where you feel like maybe I need a little extra protection. Okay, so then if your LLC is owned by your trust, your asset protection trust, not self-settled, but just any asset protection trust, then even should the attacker manage to get through the LLC, get through the corporate shield, they're able to pierce that, they're only going to bump up against your trust. So that's, I don't want to say bulletproof, but it's getting pretty close to bulletproof. And even more importantly, it gets you into that position, that very desirable position, at least the one I always think about when I'm setting these things up, of being able to answer all the questions in a deposition honestly, and there's not going to be anything they can do about it. They're still not going to be able to reach your assets. So then let's talk about the other scenario where there's a threat against you personally. You get in a car accident, there's not enough insurance, or you do something negligent, somebody gets hurt, or property damage, or you get in trouble with the authorities. I mean, there's nothing you can do about the fact that your personal assets are going to be exposed in that scenario. But what you may be able to do is protect any corporate assets that you have. So play it out. I mean, go back to our conversation in episode 38 when we talked about removing assets from your estate. Well, that's the purpose of the trust. So, maybe your personal assets are exposed, but whatever belongs to the trust is outside of your personal estate. And then there's even another level of protection, which is that, behind the trust is the LLC. So, I mean, it's going to be basically impossible for the threat that comes against you personally to get through you, get through the trust, and then to the LLC. Basically impossible. So that's as far as we're going to go. at least you understand the concept of a self-settled asset protection trust. You may have circumstances where that would be a good option for you. I personally don't really like it. I think there are better ways of doing it. You got to be able to name somebody or some entity as a beneficiary rather than naming yourself. I don't see why you wouldn't. But now you know about the concept, and you've also learned the concept of a two-layered approach. So that's not bad. Recuerda que hablamos español, and we will be back next week on a new topic. See you then.